Hello, folks. This is former head coach of Michigan football, Sherrone Moore. And he got fired last year for in an appropriate relationship with a staff member. He is facing 3 charges. And today, there was a hearing where it seems like the prosecutor and the defense are having problems getting information from the investigators. Let's look at it. Going to play this in 1.25 speed for efficiency.
Court does call the case of the People's State of Michigan versus Sherrone Moore. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Rismersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who is present in court.
Your name, sir?
Sherrone Moore.
All right, thank you. Can you grab my file back? All right. Take your time set for probable cause conference. What do we need to do today?
I've had the opportunity to talk with the prosecutor. There is outstanding discovery that we need to have before we can proceed to exam. So we're asking to adjourn the probable cause conference for 30 days to receive that discovery. And the discovery, we're talking about our phone records and Title IX documents.
Okay. Are the people going to be in possession of Title IX documents or have access to those? I guess.
It's a very good question, Your Honor.
Thank
My best understanding.
I usually ask good ones, but
You do.
go ahead.
This court always does. My best understanding in the moment is that this is not a Title IX investigation per se. My information is coming in real time, as they also say. It was a complaint apparently to the Office of the General Counsel. I have just moments before we came onto the record been informed that there is no written report. That is my best understanding. Whether or not there is some other kind of investigative information that exists has yet to be ferreted out. That effort, that process is ongoing. Ms. Michaels is correct in the aspect of phone records are being sought. All of the, just so the record is clear, all of the evidence and discovery that we have has been furnished to defense, but the investigation is ongoing.
Okay.
Whether or not 30 days is sufficient is a live and good question.
Okay, well, and let me just make sure that I'm clear. Whether 30 days would be sufficient for phone records is questionable, or for everything that Ms. Michaels indicated, I guess.
I believe my thought was everything, but I think that also applies to the phone records. Quite frankly, Judge, I don't know what that timeline is. I can try to find that timeline out and communicate that to the court and counsel, but I don't have that.
Okay, and I guess I'm not, what I don't want to get to, I guess, is a point where we're at a certain point, it may be ready to be set for exam or do whatever, and everything that these records, I'm presuming, Ms. Michaels, that you're saying from the U of M, that are records from the U of M.
Correct. It's our understanding that when you just step back a touch from the actual incident, there were statements made and things done earlier that day to the U of M, statements made by the complaining witness that are going to be important to this investigation because her credibility will always be at issue, and different statements she made to different people will need to be evaluated. So those statements are important.
Okay, I get that, but those, I mean, aren't those documents or statements that you can get on your own, or?
That's a great question. I can issue a subpoena if the court is willing to sign a subpoena. I will send a subpoena myself, but I do know based on the police reports that the prosecutor's office is also seeking those documents. And in my experience, documents, people are much more ready to turn over documents to a prosecutor's office than to a defense attorney.
We may quibble about that.
Yeah,
I don't,
Depends on one's view of life,
but
but
I take no issue with just start flowing it through us.
yeah, right. I don't have a problem with that either. It's just, I'm trying to figure out if the request is made. So, because are you attempting to try to obtain those documents?
I am.
Okay. And then once you obtain them, if you do obtain them, you're going to inform counsel or provide them to counsel.
Immediately.
Gotcha.
One more thing, Your Honor, for due diligence sake, maybe I should submit to the court a subpoena for signature, and of course, I'll serve the prosecutor, and I can also submit a subpoena requesting those records, having them returned to the court.
Well, having the results come to the court.
Correct.
Okay, and then we would. Okay, I don't have a problem with that if we're the go-between that it comes here and then goes out. I don't necessarily have that. So unless there's some legal objection to it, if you submit a subpoena to the court, I would sign off on it, I guess, to try to get this, so we can get this thing moving. 30 days. So there's also, and just so that's the discovery issue. Today, I guess that was filed a motion to quash.
That's correct. Earlier today, I, at the court window, filed a motion to quash the arrest warrant and a request for a Frank's hearing. I have a signed copy to tender to the prosecutor, and we will be asking for a hearing date on that motion.
Okay, do you want two separate dates? I mean, how fast do you want? Well, first of all, I mean, the people have to answer. So
Sure.
I guess how fast do you want this?
This can,
And what I'm indicating to you, Michael, is I can set the motion along with the PCC, hear it all at that time. Or I can give you a date for this separate and apart from the PCC.
I would like a date separate and apart. This motion is not determinative of those records. It is prior to those records. So a date to hear this motion prior to receiving those records would be our request.
Right, but I mean, presumably, actually, you're then talking about 3 hearings because there's going to have to be a hearing on the motion to determine whether or not you'd be entitled to a hearing, an evidentiary hearing. Then, if necessary, I'd have to set the evidentiary hearing. And then we would also have the PCC.
That is accurate. So a suggestion may be to, whatever the court desires.
Oh, you don't want that. No, go ahead. Okay, that's fine.
You know, this is a lot. So in the expedience, we'll leave it to the court's discretion as to how you want to set things.
That part of it, but we'll try to get through it as quickly and as expeditiously as possible. But the people have seen the motion. How long are you going to need to respond to the motion for the first part of that?
So although I was aware that a motion was filed this morning, I was not served with a copy until moments ago. I have obtained a copy through the court file prior to being at this moment and have had an opportunity to begin to flip through it. I have not consumed it in its entirety. How long to respond was the court's question?
Yes, for the first part of a determination as to whether or not there would even need to be an evidentiary hearing in this case.
Court's pleasure, but at least a week.
Easily. Okay. And
Yeah, usually on my channel, we've been watching Judge Simpson for years. He rarely has any. He really doesn't like when the prosecution shows up and making excuses for investigators not turning over evidence. And this is not the first time in Judge Simpson's court that we have heard this and similar stories about prosecutors desperately trying to get information from the local police department. It's not the first time. It's almost as if it is a pattern, especially with cases with some, what do you call it, importance, high visibility, celebrities. It seems like this specific department really doesn't like handing over evidence even to their own prosecutors. And that's a real issue. Because the defense here for former Michigan head coach Sherrone Moore, they need this to start formulating a defense. And the longer it takes, the longer this is, we will have to rely on mass media headlines, which, to my understanding, when looking into this, are quite vitriol against Mr. Moore. So that is a really, really big issue. And Judge Simpson, I've seen him losing it. And he doesn't do that often. But once he does, you better watch out. Because also, as a prosecutor, I'm sure she's doing a swell job usually. Put some pressure on the investigators. Haul your ass down there and get the information. And if you don't get the information, get the investigating officer in front of Judge Simpson. And I can assure you, that officer, if he doesn't have a clear answer to what's taking so long, Judge Simpson will shoo him out, spit him out, and then the information will be delivered magically quite fast.
Do you like me to look?
Well, I even have to set it on off day,
Yeah, I was thinking like a Monday or Tuesday.
on Monday, 21.
Yeah, so just tell me how far.
If I give it 10 days. A second, I'm just gonna do a research in about 10 days. And just give me a week to go through everything, so around this time. Yeah. Here's one.
I think so.
Also, it's great that it is in front of Judge Simpson because
Will that work?
we will find out stuff through Judge Simpson's stream that I can almost guarantee that legacy media will not tell you.
Yes, that-
All right. So with reference to the motion, I'll have the prosecutor's response will be due by maybe longer than a week, February 2nd.
Thank you.
February 2nd, 2026. I will then set this for hearing on the motion. For February 9th,
let's get 1 p.m.
2026,
Yeah.
at 1 p.m.
Your Honor, may I speak up?
Yes, go ahead.
In the moment, I have a murder case set to start on that date.
That's,
That may
that's,
change, even within the end of the day today, that may get moved. But in the moment, that is day one of the murder.
that's day one.
That's not a good date for me either, Judge.
You give me a date, and let's see what we can figure out.
Tuesday,
Well, Tuesday the 10th is not going to work if the murder trial goes. So
Tuesday the 17th at 2 o'clock,
Should be fine.
That works for me.
at what time?
2 p.m.
All right. So the motion will be set for February 17th, 2026. You said 2
Yes, sir.
at 2 p.m. Okay, and that will be an in-person hearing. We then, in understanding that, depending on the result of that motion, there may be another date that is set. But I'm not going to deal with that at this point because a determination has to be made. So I'll adjourn the probable cause conference. Normally, I'm not really going to care about the date itself, but with all some of the logistics that come along with this case, I have to because of other docketing concerns. Will March 19th then work? I realize that's a little bit longer than what you asked for, but we're going to see each other on the 17th. And then I would adjourn this out to the 19th, hoping that all discovery, at least at that point, is clear.
That works for the defense.
Works for me as well. Thank you.
All right. So probable cause conference will be adjourned to March 19th, 2026, 9 a.m. or as your invite indicates. there anything else from either side?
Nothing for me.
No, Your Honor.
All right,
Thank
thank you
you
very
very
much. Bond will continue.
Thank you.
Thank you.
This is how it's done in the lower courts as the case is developing. Nothing unusual. That discovery sometimes takes time, but as I said earlier, this specific police department I've seen before dragging their feet. And at one point, Judge Simpson will haul their ass into court to explain themselves. And if he doesn't like the answer, you're in deep trouble. Now again, the case against former Michigan head coach Sherrone Moore is, ow, Mr. Jingle, stop biting me. I know you are biting me out of pure affection, but it hurts. Now, Mr. Moore is charged with third-degree felony home invasion, misdemeanor stalking, and misdemeanor breaking and entering. Now, the defense claims this is made up. Mr. Moore is innocent of these charges. As of now, since we don't have more information than the initial charging, it's a he said, she said situation. That will develop. Of course, it will develop. Now, generally, don't screw people in the office, especially if you are in a position of power and the other party is more or less your subordinate. It will go down in flames. One party will suffer, or both parties, as in this case. It will happen. Do not stick your dick into a subordinate. And if the gender roles are reversed, do not spread your legs for subordinates. Don't. It's a really, really bad idea. This will be an interesting case to follow because it is in Judge Simpson's court. You tell me, guys, if this is so. Well, I'm going to look for it anyways. So, but just leave me a comment telling me if you have information that you feel that I should know. And yeah, thank you for listening in, folks. I'm Nick, your Viking lawyer, Santa Claus, whatever nickname you find suitable. From me and Mr. Jingles, you all have a good one. I will see you in the next stream or video. Bye-bye.